Hi everyone, this is Dr. Victoria Nalule. And in today's discussion, in today's webinar, we want to talk about the energy disputes, just a brief background on the energy disputes and the role of international arbitration. So before I start, I need to note that energy disputes are likely to escalate globally, but on the African continent, we're seeing that these are likely to play a big role in international arbitration because the recent data from the International Energy Agency, their 2022 report indicates that the African continent would need over 190 billion US dollars to meet its energy needs during this decade. So 190 billion US dollars, that's more investments in the energy sector on the African continent. And most of these investments are going towards clean energy. So with a flow of massive investments in the energy sector, it means that obviously there will be a presence of various international energy investors on the African continent, and where their investors, where their agreements, where their projects, disputes often arise. And for the energy sector, most of the agreements often provide an arbitration clause, implying that the disputes that are likely to arise in the energy sector will have to be resolved through international arbitration. Hence, international arbitration will play a big role in ensuring the resolution of the disputes that are likely to arise in the energy sector. So in this short video, I want us to explore more on energy disputes and the role of arbitration as a dispute resolution mechanism. So by introduction, I'm Dr. Victoria Nalule. I'm the CEO of Nalule Energy and Minerals Consultancy. I'm also an energy arbitrator at the Energy Disputes Arbitration Center in Turkey. I'm an author of several books focused on energy mining, and our recent book, it's a live book project. It's focused on international arbitration in the African energy and mining sectors. So this topic is really a topic that I'm so interested in. So when we're talking about energy disputes, we have to first look at the nature of the energy sector. First and foremost, energy investments are very expensive ventures, often requiring massive capital, which is beyond the reach of any government. And as such, for energy projects, you will see the presence of international energy investors. So the main parties to an energy agreement, for instance, let's take the example of the oil and gas agreement. It will mostly be the host government and the international oil company. But however, you have to remember that this differs depending on the jurisdiction concerned, because in the current video, the previous video we have just recorded today, we're talking about the energy sector in the USA and how the private people have ownership over energy resources or oil and gas resources. So depending on the jurisdiction concerned, also the nature of the energy sector will be different depending on who owns those resources. So first and foremost, these projects, besides being capital intensive, they're also often for a very long period of time. So the duration for these projects, it's often 20 to 30 years, or even 35 years. So within the 35 years, the 20 years, the 40 years, disputes are likely to arise in the energy sector. And these disputes are often resolved through international arbitration. One might ask, why don't we resolve the disputes through litigation, mediation, or conciliation, neutral evaluation? And the answer to that, especially for litigation is not often preferred as a dispute resolution mechanism for the energy projects, because investors often fear that besides litigation being costly and time consuming, there's also the influence of the host government, the politics in the countries, especially for developing countries, because the courts, the judiciary, the executive, sometimes the judiciary might not be independent. And given the nature of the energy sector, investors often prefer to resolve the disputes through international arbitration because it's considered to be more independent, but also most importantly, the arbitral awards are final, hence giving arbitration or hence making arbitration preferred mechanism for resolving disputes in the energy sector. So in the slide, we just talk about the main difference between arbitration and other forms of dispute resolution, such as mediation or conciliation, is that a mediator or conciliator can only recommend outcomes and the parties can choose whether or not to accept those recommendations. By contrast, an arbitration tribunal has the power to make decisions that bind the parties. Additionally, arbitral awards can easily be enforced in courts of most countries without rehearing of the issues. So this is also a very important aspect to take into consideration, that the arbitral tribunals, the arbitral awards can easily be enforced in different jurisdictions. So what is international arbitration? It's an alternative dispute resolution mechanism that involves the settling of disputes between two or more parties by referring the dispute to an independent and impartial third party known as an arbitrator or a panel of arbitrators. But with respect to the energy sector or even to arbitration in general, you should have a valid arbitration clause in your agreement. So whereas parties often try to negotiate the other clauses in the agreement, let's say in the oil and gas agreement, those clauses are important, but also having a valid arbitration clause is very important because it's the basis for any claim to be brought under arbitration. Without an arbitration clause, then there is no foundation, there is no jurisdiction of foundation of the arbitral tribunal. So for lawyers who are listening to me, as you're negotiating the petroleum agreements or even mining agreements, ensure that there is a valid arbitration clause. And the contents of the arbitration clause, in summary, they should clearly specify the number of arbitrators. Is it going to be one arbitrator or it's going to be a tribunal of 3 arbitrators? It should also state the seat of arbitration. The seat of arbitration is very important because it will determine which courts are likely to have influence over the arbitration. And then the other important thing is it should state the procedure rules that will govern the arbitration. You also need to look at the various procedure rules and consider which rules are likely to favor the parties concerned, and those should be agreed on in the agreement through inserting them in the arbitration clause. So when we talk about the arbitration clause, the most important article is Article 2 of the New York Convention. Article 2, Clause 1 and Clause 2 of the New York Convention make emphasis on the presence of an arbitration clause. It states that each contracting state shall recognize an agreement in writing. So here you notice that the arbitration clause has to be in writing, under which the parties undertake to submit to arbitration all or any differences which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. So the arbitration clause should be in writing, and it should also clearly state that the parties intend to submit all the differences, all or any of the differences to be resolved through international arbitration. And then the term agreement in writing shall include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. So in these slides, we see that the arbitration clause is really important. And for petroleum agreements, they often include an arbitration clause. For instance, if you look at Article 26, Clause 1 of the Petroleum Sharing Agreement, for Uganda, between Uganda and Talo, it has an arbitration clause which reads as follows: subject to Article 14, Clause 2, any dispute arising under the agreement which cannot be settled amicably within 60 days shall be referred to arbitration in accordance with the United Nations Commission for International Trade Law. The arbitration shall be conducted by 3 arbitrators. So here you note that first the arbitration clause of the arbitration agreement is in writing, and then it talks about any disputes arising under this agreement. So any dispute that arises has to be settled through arbitration. And then to talk about the procedure rules, which are the unilateral arbitration rules. So these are the procedure rules that they have agreed upon. And then they also mentioned the number of arbitrators. And in this case, they have mentioned 3 arbitrators who are to be appointed in accordance with these rules, with the unilateral arbitration rules. And here they give the seat of arbitration, which is London, because also in the arbitration clause, you have to specifically specify the seat of arbitration. So this is a good example of an arbitration clause that is found in a petroleum agreement. So all the agreements should really contain arbitration clauses. So there are various energy disputes that have been settled through international arbitration. You can go ahead and read about the case of Texaco Overseas Petroleum Company versus the government of the Libyan Arab Republic. This is a 1978 case, but it has various issues with respect to the choice of law in clause 28.7, and you can read it says that this concession shall be governed by and interpreted in accordance with the principles of law of Libya common to the principles of international law, and in the absence of such common principles, then by and in accordance with the general principles of law, including such of those principles as may have been applied by international tribunals. So what are the main sources of energy disputes? What causes these energy disputes? There are various reasons that may lead to a dispute in the energy sector, but for the countries that offer stabilization clauses, these clauses have often been a source of energy disputes that end up being resolved through international arbitration. You can refer to I think I've recorded 3 videos on stabilization clauses. You can refer to those videos to find out what the stabilization clauses are, and also find out on your own which disputes have arisen due to the breach of the stabilization clauses. So you can do further research on that. And also the other thing, the taxation disputes. We have seen many cases in Uganda and Ghana relating to taxation disputes in the energy sector. So you can also take some time off to look out for the cases that have been brought under international arbitration as a result of disputes arising from taxation clauses. So that is also something you should look out. Then outside the oil and gas sector, we have also seen different cases that have arisen due to breach of provisions in the power purchase agreements. And this was the case in Balkan Energy Limited in Ghana versus the Republic of Ghana, which related to the failure of the Republic of Ghana to meet its commitments under the power purchase agreement, specifically the requirement that Ghana provides adequate site electricity and connects the bush to electrical grid. So here I give the brief facts about this case, which relates to breach of the power purchase agreement. So you also have to be very careful with the power purchase agreements and ensure that whatever commitments are put in those agreements are met. Otherwise, failure to meet your commitments under an agreement, be it power purchase agreement, be it the petroleum agreement, be it the agreements relating to the renewable energy sector, any failure to meet your commitments can lead to a dispute which would likely be resolved through international arbitration. So we have seen a rise in various international arbitration institutions in different countries, in different regions. We have seen the International Chamber of Commerce. We have the Singapore International Arbitration Center. We have the Kigali Arbitration Center in Rwanda. In Kenya, they have their Nairobi International Arbitration Center. In Lagos, they have several arbitration centers. So we're seeing an establishment of different international arbitration centers. And for the energy sector, we have also seen the establishment of the Energy Disputes Arbitration Center, which is based in Turkey. It's called EDAC, Energy Disputes Arbitration Center. Yeah, so we're seeing a rise in different arbitration center, which is really evidence that international arbitration has become very important in the 21st century. But the energy sector, like I mentioned, it contributes significantly to the various cases that are being resolved through international arbitration. And also statistics show that due to the increased investments in the energy sector, it means that there will be increased disputes. And as such, international arbitration will play a big role in resolving these disputes. For instance, in 2020, energy disputes accounted for about 18% of the total caseload of the International Court of Arbitration and 26% of the caseload of the London Court of International Arbitration. So this is evidence that international arbitration is becoming prominent in resolving the various disputes in the energy sector, in the oil and gas sector, in the electricity sector, renewable energy. And like I mentioned, recent data shows that we are likely to see, or the African continent, for instance, will require over 190 billion US dollars to meet its energy needs in this decade. So that implies that once we see lots of investments flowing into the energy sector, disputes are likely to arise, and as such, international arbitration will play an important role. So thank you very much. Do not forget to subscribe to my YouTube channel. Remember, we're trying to reach 200 videos before the end of 2022. Subscribe to my channel and stay tuned because we're going to be recording more videos. Have a lovely day and bye-bye.